Okay, welcome back to our next panel, which is called Managing Insurance Issues Before and After a Cyber Attack. This is a key issue that just keeps getting more and more important. First up, I'd like to introduce Scott Goddess, the co-chair of Barnes and Thornburg's Data Security and Privacy, and also the Insurance Recovery and Counseling Groups, where he has helped insureds recover more than $1 billion. A unique combination of leadership responsibilities for Scott. He's filed two landmark appeals on behalf of insured against insurance companies who denied charges, both in the 11th Circuit on behalf of the insured after a data security incident. And notably, he handled these cases from start to finish, including the appellate argument. Welcome, Scott.
Thanks, Bruce. Good to be here.
Next, let me introduce Sean Hoar, a partner and chair of the cyber team at Constangy, Brooks, Smith, and Prophete. Sean is an IR pro, possessing every cyber certification there is. It makes him as much of a technologist as a lawyer. He came up serving as the CHIP for the U.S. Attorney's Office in Oregon, the computer hacking and intellectual property lawyer, where he was the point of contact for the FBI, the Secret Service, and Homeland Security in system intrusions and other digital crime emergencies. Also been an adjunct professor for a decade at Lewis and Clark Law School, and served as executive director of the Financial Crimes and Digital Evidence Foundation for 22 years. Sean, we always love having you with us. Welcome.
We appreciate it.
Next, I'd like to introduce Scott Lashway, the managing partner of Manatt's Boston office and co-leader of Manatt's Privacy and Cybersecurity Practice Group. He represents clients in a large range of industries and has a significant focus on the healthcare, financial services, and technology sectors. He previously worked as senior in-house counsel and head of investigations for Mass Mutual, where as a member of the disputes resolution team and the head of investigations, he counseled executives, board members, and multiple business lines on a wide variety of matters, including litigation, investigative matters, and business matters. Great to have you with us, Scott.
Thanks a lot, Bruce. Great to be here.
Our next speaker and our moderator today is Kari Rollins, the managing partner of Sheppard Mullin's New York office. She's best known as a cyber lawyer, but she's also a fierce litigator and advocate during the tumultuous times of IR and then the planning phases of IR. She's a member of the drafting committee of the Sedona Conference, responsible for drafting and publishing the Sedona Conference Incident Response Guide, and also an adjunct professor at DePaul in Chicago, where she teaches a course on data breach law. Welcome, Kari.
Thanks so much, Bruce. Happy to be here, and thanks to Cybersecurity Docket for having us. Absolutely.
Finally, let me introduce Carolyn Purwin Ryan, who's joining us today from London. She's a partner at Mullen Coughlin, a firm dedicated exclusively to IR and data security that has now grown quickly to over 100 professionals. Mullen provides third-party privacy defense legal services, also aids in IR planning from tabletop exercises to regulatory compliance, and has a master's of law and tax to boot. Welcome, Carolyn.
Thanks, Bruce. Looking forward to it.
Thank you, Carolyn. Kari, let me turn it over to you.
Great. Thank you so much. And welcome, everybody. As Bruce said, today's topic is managing insurance issues before and after an incident. And just as the title suggests, we're going to talk to you about insurance preparedness in the cyberspace, i.e. things to think about in your application, the type of coverages you'll want, as well as managing your incident response and liaising with your insurer to help you and put yourself in the best position to have the costs of a cyber incident or privacy violation covered under your existing cyber policies, and then what to do in the after if for some reason, unfortunately, there's a dispute about coverage. So, as everybody knows, I think here today, data breaches can be very expensive, from the fees associated with the forensic investigation to the notification costs, fines and penalties, and then resulting litigation and even counsel's fees. Knowing that, one of the first items that I wanted to discuss with all of our panelists here is how we plan for the inevitable data incident, or what we do when we're called in to investigate and respond. One of the biggest questions we always ask is there cyber insurance? Do they have it? Are they in the process of applying for it? Are they going through a renewal? And what does it cover? So the first piece, the application process, is critical in evaluating the type and scope of coverage that you might need and the type of policy you might need. But the application itself is also just as important as understanding those types of coverages. So for my first question, and given the breakneck speed at which claims are being submitted now more than ever, I'm going to toss it over to Scott Goddess to walk us through how to thoughtfully manage the cyber application process or renewal process to avoid unnecessarily creating risk for a company in the answering of these long and often multi-question and multifaceted questionnaires.
Thanks, Kari. The application process, right, and the application itself right now has been serving two purposes. One, tell the carrier about your business and the size of it, some of the practices that the business follows. But two, insurance carriers know that they can rely upon the application to pull the rug out from underneath unwitting policyholders, depending upon the answer given. So let me talk a little bit about number two and the importance of completing number one in a way that the carriers later on says what they wanted. So a lot of insurance policies say that New York law controls. And a lot of insurance carrier lawyers say that New York law, if it applies, allows an insurance carrier to rescind the policy with a very low standard of proof, where they would say all they have to demonstrate is an inaccurate statement in the application, whether it was intentional or not, they would say. And they would also say, well, if we were to charge a different premium, of course, it'd be pretty hard pressed to find a carrier to say we wouldn't have charged a different premium had your answer been different. So again, that's all the insurance company positioning and the arguments that they make. So, hey, this answer was wrong, and therefore we can rescind your coverage, which is an unbelievably bad day in the office to go to your board and say, well, we bought tens of millions of dollars of cyber insurance, but the carrier says that they can rescind the policy. So what does that mean in terms of the application? Well, as applications have gotten longer and more detailed, being mindful of the fact that the carriers are getting more aggressive. One carrier even filed suit recently seeking to rescind the policies based upon statements made, is not just have somebody, a single person, whether it be a risk manager or an IT person or otherwise, fill out the application. But in a perfect world, it would involve multiple people, which I know nobody wants more homework to do, but involving the IT personnel who can drill down in terms of what standards, practices, or otherwise, whether it be multi-factor authentication or other things along those lines regarding updates, how that is done across the entire enterprise, involving the risk manager who's understanding the insurance program and what is being sought. And again, in a perfect world, involving counsel that can advise about data security practices, can advise about insurance issues, can advise about how the company goes forward and thinking through the answers. And the last kind of actionable takeaway is when filling these out with your now super friends in the Hall of Justice, figuring out how you answer this, is being mindful that you should not feel limited by how the application appears. So, for example, even if it's a form, a PDF that has a radio button of "Do you do this? Yes, no," and your answer is "Well, kind of." If you say yes, be mindful of how insurance company counsel would treat that at the time of an event. So, what do? Attachments, and edit the PDF and somehow get somebody who's technically savvy who can put in a note that says, please see attachment A. And in attachment A, if you're questioning, did question number 9.f mean X or Y? Well, then you explain. If it means X, then the answer is this. And if it means Y, then the answer is that. Because again, the application the carriers will tell you is designed to figure out how they can underwrite your company. But what their lawyers won't tell you at that time is they'll also try to use it to get rid of coverage. Now I recognize that in the vast majority of times, this is not what happens. But I stay employed because the vast majority of times is not 100% of the time.
Scott, I think when we were talking about in preparation for this panel, examples that we had all experienced with our clients of, applications that appear to present very much a binary decision. Do you have MFA deployed across your environment? Yes or no? And what we discovered is in a lot of instances, it's well, yes, as it relates to maybe these products or these endpoints, but no, as it relates to these, or yes, only as it relates to access to the environment by our employees or through the VPN, but not MFA enabled for our vendors. So I think, and I'll present this to all of the panelists, Scott L. and Sean and Carolyn. What are some other examples, or I'll call them sort of hacks, other than adding like a text box to an application or an addendum that you've used, again, to ensure that the application really reflects the true state of the security environment or program or controls when only presented with maybe binary options on the application?
Kari, this is Sean. I might go just a step before that, is to make sure you ultimately answer the question accurately, is to make sure you have the right person answering the question. And as part of the process, when we do incident response planning, one of the most critical elements of an incident response plan is to make sure that client is placed with a proper cyber insurance product. And if they've already got one, that's great. Then during the renewal process, we make sure that they've got, it's a cross-functional plan perhaps, and planning for the mitigation of economic loss. Of course, you want to make sure you've got the right cyber insurance product. But oftentimes we're concerned because we have somebody that may be risk compliance centric or financial centric, but maybe not informed from the information security or information technology unit. And just like incident response planning generally as a cross-functional exercise, we need to make sure those people who are familiar with the controls and how they're enabled, whether it's multi-factor authentication or an endpoint detection and response tool, make sure that whoever is answering that question actually knows what the current state of the environment is, as opposed to guessing or speculating. And that's what I see as one of the primary problems is the ultimate result is not an informed result because you don't have the right people at the table making the decision.
Yeah, and Sean, just to jump off a little bit of what you were saying, I think another part of the process is, talking through with an insured and knowing what all of the possibilities that you do have are. Because a lot of insurance companies that are out there actually offer a lot of proactive services that are out there that people don't take advantage of. So if you have a good relationship with your broker, you have a good relationship even with your coverage attorney, they're going to tell you about some of these proactive services to know where some of your open ticket items are. And to so with the ultimate, responsibility and the ultimate understanding of, hey, look, no one wants to call the incident response attorney ultimately, right? So that really is what you want to try to do, is to curb some of these incidences before they occur by utilizing some of those proactive services.
That's a great point, Carolyn, and that actually is a nice segue into one of the other topics that we wanted to cover in terms of preparedness, which is, again, equally as important as the thoughtful management of the application process is the need to understand the coverages your company will need in order to address the variety of risks facing your organization, or as you said, sort of the proactive open items that you may have that you want to have addressed. Again, it's not so much just a matter of evaluating what first-party coverages you have or third-party coverages you have, but it's also how are you going to deal with the flood of privacy litigation that continues to barrel through our courthouses across the country. Really trying to understand whether your cyber policy would cover claims beyond those just stemming from a data breach. It's a critical question. So I'll pose this next one to Scott L. So with the variety of first-party and third-party coverages, or what are the variety of first-party and third-party coverages that an organization may need when facing a data incident or when facing claims of a privacy violation different from a data breach? And do most cyber policies today include those coverages, or do companies need to consider supplementing or augmenting their cyber coverage with other policies?
Yeah, thanks, Kari. And so why don't I get started maybe from two perspectives on this topic, because I think it's important and we all experience challenges, and I think we've experienced these similar challenges from time to time as risks have evolved and certainly the law is playing catch up. So one of those challenges is a conflation of privacy and cyber risk. So in common parlance within organizations, there's often confusion between what a cyber risk is or a cyber policy is, incident response, versus a privacy situation. And obviously, they're close relatives in our world, but the insurers often treat them differently. So if you look at, for example, the wave of litigation over the last 12 months related to wiretapping cases, which some would argue relates to cyber and some would argue relates to privacy, there's an argument that the cyber policies that are on the market may not be providing coverage where the insureds think it should. And so an understanding of where cyber coverage begins and ends within your organization starts with an evaluation of what truly is cyber risk and what is privacy risk, and an evaluation of the policies that you have and the policies that are available and whether or not they're meeting those risks appropriately. I think the easy way of doing that in terms of kind of the hack is having an informed conversation, to Sean's point, to Carolyn's point, and to Scott G's point, having an informed conversation amongst a group of people at your organization, not just the CFO or legal, who often is weighing in on the purchase of policies, but involving many constituents and decision makers in that evaluation. What do we need and why do we need it? The other angle, just quickly, is this concept about, and this has been around for a while as well, but it seems to be renewed in light of Delaware's recent case law about where cyber policies end and where D&O policies may pick up. So we've known for decades now that organizations have fiduciary responsibilities, that the board can discharge those down to management. And that's often where we've looked at cyber to provide one mitigation tool for risk management. It's not, cyber insurance. It's not the only tool, obviously, but we've looked to it collectively. But now courts, at least in Delaware, are telling us that directors and officers may have individual responsibilities with respect to some of the management of material risks at organizations, separate and apart from their typical fiduciary responsibilities as officers or directors. If you apply that over to the cyber and privacy world, then you start thinking, well, geez, is D&O insurance going to be back at the table with respect to the propagation of risk from a security incident, both from a coverage perspective during the incident and then after, if you have regulatory and litigation needs, and obviously the prosecution of a security professional in the last year got everyone's attention with respect to these types of needs. If you combine the two of them, I think you're left with that world is getting more complicated, and understanding the application of the available coverage to your particular entity and the risks and decision makers is critical.
I think, and this is again another question for the panelists, but in my experience, there have been a lot of instances where there's been a data incident and maybe there's been an enforcement action or litigation filed against either executives or the board, or derivative shareholder litigation filed against them. And there has been a battle as between the cyber insurer and the insurer supporting the E&O or D&O policy. And so when you're preparing for and you're evaluating the coverages you need, what are some of the steps you can take to evaluate if there is a gap in coverage there as between those policies, right? Under which policy would management be covered? I know from my experience, sometimes it's just as simple as a conversation with your experienced broker and a conversation with the insureds or the policyholders to better understand where is the gap in coverage, and if this occurred, would your cyber policy cover my directors, my officers, or would this fall under an E&O policy? What are some of the steps that you all have taken to help your clients navigate potential gaps in coverage or foresee where there might be gaps in coverage?
So if I can jump off with this one, the ideal way of doing it is practically a mock tabletop exercise and thinking about the kinds of events that you, in a blue sky situation, could think about could possibly come down. And having that conversation with the broker to understand at a high level what the policies are supposed to provide, and having that conversation even with the underwriter, and being mindful that the underwriters don't always know how the policy would respond in a certain circumstance, and not taking a high level back of the hand sort of answer. So one example I have in that context was I worked with a company with a foreign parent, and the American organization was buying its first cyber policy. And they had questions. Well, what happens if the foreign parent is involved in some way? How would the policy apply? Particularly if it was a ransomware sort of event. And I looked at the language and I said, I have some questions as to what the underwriter would do. I know what I would argue, but I don't know exactly what the underwriter and the claims team and the claims counsel would say. So the underwriter got on the line, and she let me leave out all the adjectives. She said, well, I like to turn to the policy language first. I said, great. I agree. Let's turn to the policy language. Let's look at section 1.b.3. And here's what it says. And she had a long pause. And I said, well, how would that apply to the circumstance involving the American company and the foreign parent? And she said, I'll have to get back to you on that. And so these policies are, not to be self-aggrandizing, but the policies are complicated and they're not standardized across insurance carriers, and not even across the same insurance carrier. There are carriers that sell different forms to different insureds, and depending upon the year, they update them. And so if there are questions of, well, what would happen if there was a securities claim? What would happen if there was some kind of cyber event that gave rise to a securities claim? Sitting down and envisioning what the sorts of claims could be or have been asserted, and pulling out the policies and walking through in a very careful step-by-step process is the best way to understand what's a possible outcome in terms of coverage.
Thank you, Scott. That was really helpful. Sean, it sounds like you have some thoughts too.
Well, to Scott's point, one of my biggest concerns is making sure everybody, the broker, as well as the broker in particular, understands the threat landscape faced by the business model. And I'm oftentimes surprised that we're not looking at the trends with regard to information security, not just ransomware attacks and business email compromises, but the spike in fraudulent wire transfers. And then, is that a social engineering matter? Is it a crime matter? Is it a privacy matter? Is it an information security matter? And what component part of a policy does that fall into? But if we don't understand that this may be a business model that does a lot of ACH or wire transfers, receipts or sends, and then we may not be capturing what we need to do to mitigate that economic risk, versus a consumer-facing model where you may have more PCI compliance-related issues versus something else. But let's look at everything that the company does and get a feel for where the economic risks are, and make sure there's a component part that might apply to it. And it really does take that broker to interface with information technology and security, risk compliance, perhaps legal, the CFO. Again, get the right people at the table to understand what the threat landscape is facing the business model. And then you can find that component part. And hopefully, with someone like Scott, perhaps you then also have that conversation to understand how that policy then applies to it.
That's a great point, and raising the point about the broker is fantastic too. Because while you need to have the right internal team or group of team members evaluating your insurance needs and the risks presented to your organization, there's a significant benefit to relying on and working with in coordination an experienced broker who understands the evolving landscape of cyber risks and privacy risks, right? Because the difference is nuanced, and it's going, and frankly, it's evolving every day as we see plaintiffs' counsel get more and more creative in how they pursue perceived privacy violations under, in some cases, statutes that were written in the 80s to protect lists of video rentals from Blockbuster. So I think that's right. Relying on an experienced broker too, or at least looping them into the assessment for cyber coverages is really important. And to Scott G's point, asking questions, being unafraid to ask questions rather than just fill out an application or review the documentation. Having really meaningful conversations, I think, is just equally as important.
And Kari, can I jump in on that?
Yeah.
Sure.
Your comment about documentation is really a super salient point. And the reason being that when people buy insurance policies, cyber or otherwise, as they're corporate buyers, they rarely actually get the insurance policy at the time that they're trying to buy something. What they typically get from the broker is a listing of carriers that are willing to underwrite at the primary level, for example. Here are 3 carriers that are willing to sell to you for a $10 million policy and a $1 million retention, for example. And here are the premiums. And then better brokers will give lists of kind of comparing what they have or what they don't. It is extraordinarily rare to get the full insurance policy form, and even more rare to get not only that, but then the endorsements that will be added onto it. And so we talk about clients reviewing policies, but as they're buying, the industry has a practice of simply not providing the policy for months after you've said, okay, I'll buy from you. I'll buy from this carrier. And so, the expression of pig in a poke, where do you think you were getting a pig in the bag, or were you getting a cat in the bag? And the carriers have created this process where they typically just don't turn over the policy forms as people are in the process of buying. And you can ask for them. Policyholders can ask for them. And in a perfect world, they ask for them, get them from the broker, and have a chance to sit down and review and understand what's being proposed.
And Kari, can I just add something too? I know we're going to move on, but one of the things that you're hearing is the application process and the purchase decision is a static snapshot of the risk within your organization that you've been able to identify. We all acknowledge that security risk is evolving by the minute and the day. That one of the challenges organizations have is to apply the evolution to the static snapshot for that given insured period, right? And so that's something where, say your renewal's on December 1st, there's a 8-week run up to the renewal process. The risk isn't mitigated at the time you get delivery of the policy or the policy coverage form. The risk is mitigated at the time when the insurance policy is triggered. And so you need to stay very well connected, if you're a security professional, to what coverage is available as that risk is materializing or just simply evolving outside your organization.
And I think that the coverage piece we have a slew, and I've been trying to catch a lot of them, but we've been sort of inundated with different questions from the audience, several of which are sort of focusing on questions about coverages, and then another which is focusing on how, what is advice for small companies who maybe don't have the manpower behind them, like the outside legal teams on call. How can they manage this application process when they need it, just as much as any other large organization? So just quickly, I'll start going off of what our script was for today, but I'll start with maybe one of you can provide a quick rundown, just so everybody understands, of what some of the general first party coverages and third party coverages you would expect to see under a cyber policy in order to help a company bear the cost of a data incident, including things like for business interruption, replaced property, devices, et cetera, as well as, to Carolyn's earlier point, what we might see in terms of coverage for proactive services. So Scott, Sean, or Carolyn, somebody want to take that sort of on the fly question?
Yeah, I'm happy to be translate.insurance.com for everybody for a quick minute. The cyber policies, again, after I made the crack about they're not standardized, a standalone cyber policy, as opposed to something else somebody buys, like a business owner's policy or general liability, where they say, hey, there's some cyber in there. Look, if you can get that, great. But a standalone policy should be the most comprehensive, and it will be, they almost never are called cyber insurance, but the broker should call them that. And what to look for, taking aside what a broker calls it, what the carrier calls it, are the coverages for the costs you'll incur and the potential liabilities. So at a starting point, a standalone cyber insurance policy should include coverage for what they call incident response or breach response or event response costs. And that means coverage from minute one for the cost of hiring outside counsel, like all my co-panelists, to quarterback the entire investigation. It should include coverage for the cost of hiring a forensics firm to figure out what happened and how do we handle it. It should include coverage for costs of PR if you decide that PR is the way to go. It should include costs for providing notification if that's something that you're obligated to do. So that's with any cyber event. Ransomware specific, because that's what we're talking about, then the question is there a specific provision of the policy that provides coverage for the cost of paying a ransom if that's the direction in which seems to be the best way to go. Sometimes it's called cyber extortion. Some now call them ransomware. Something that goes hand in hand with that, but is typically a completely separate section, is what they call first-party business interruption costs and extra expense, which means coverage for the costs of lost income or lost profits, and coverage for the cost of extra expenses incurred for purposes of getting the company back up and running. All those should be in a really good cyber policy. And then the so-called third party, which is defending against third-party demands, inquiries, etc., would be cyber/privacy liability, now typically based on network security liability, baked into one section. And that should provide you with coverage for the cost of defending against a lawsuit or a claim letter or demand letter, as well as if you have to settle or if you take a verdict. Last piece on that typically is what's called regulatory investigation coverage, dealing with governmental investigations. And again, if you ultimately have to come up with some kind of resolution for the costs of that. And so when you step back, if you're a small company, perhaps you don't have outside counsel on call, but thinking through the sorts of costs that would be incurred, ideally you would have every category of those brought to bear. And if the broker is talking insurance speak and it's hard to really get your arms around it because everyone's eyes glaze over and they hear, oh, it's first and third party and the things you need. So, whoa, what does that exactly mean? Ask them, if I have a problem, if I have ransomware and I want to hire a forensic company, am I going to get covered for that? Ask specific questions like that. And that should get you down the path of understanding what you're getting in the policy provided.
That's great. Thank you so much.
Just one comment there, though. So I think it's great to expect a lot out of your insurers, but I also think you need to accommodate, regardless of the size of your sophistication of your operations, that insurance isn't the solution to cyber risk. It's just one of the many tools that's available to help mitigate some of the risk. And I think insurers are pretty open about that, as are really informed brokers. So one thing I would add is find a local informed broker who actually specializes in this space. There are some great ones out there. Some of them are at the real big shops and some of them are at the medium size. There's also local ones. It's not a one size fits all. And the brokers can really help you if you can't afford, one of the expensive lawyers on this chat.
I think that's great advice, Scott. And I know we've only got about 10 minutes left on this panel, so I do want to move to a couple more of our topics that we had, but I'll continue to try and sift through the multitudes of questions I'm getting from the audience to have those answered. But one question I did want to address, and this again goes to sort of how the thoughtful the way we thoughtfully communicate with insurers, right? Because there is a need to keep them informed about an incident as an incident is evolving. They have to understand the scope. They need to set reserves. They also need to, in a lot of instances, ensure certain boxes are checked to have approvals for the payment of things like ransom. But at the same time, a lot of investigations today are conducted at the direction of counsel and under privilege in anticipation of litigation, because I think everybody knows today that data breach litigation has really become somewhat of a cottage industry. And so my question is next for Carolyn. How do you balance the competing need to communicate with your insurer, but also protect privilege over investigation, protect privilege over the investigation and the analysis, understanding that there isn't a privileged relationship between the insurer and the organization and you as their representative? And how do you thoughtfully communicate with the insurer, again, so as to ensure that there's enough information so they can set reserves and evaluate coverage, but also at the same time, avoiding the risk that statements made about the incident to the insurer could be used against the company?
Yeah, so and that's a good question, Kari. So one of the things I will certainly say right from the beginning is that it is my argument that the insurance company is an arm of the insured, right? So that attorney-client privilege will apply. It is something that it is certainly an area that has been tested across the board. I will say this, from my standpoint, one of the first conversations that we have from the insured is talking about this very issue about attorney-client privilege and the importance of being able to be open and have those communications. But we do have those conversations. We have them, we have them not only just in, on vocal conversations, but we have them in writing. And we say, hey, look, there's questions that the insurance company may ask as we go along, and they have copies of everything as we go along. And if, just in my role, we don't get involved in the coverage piece. But if you do have any sort of questions when it comes to any sort of coverage issues, certainly contact your broker, contact your coverage counsel. They're the ones that, may be asking about those questions. But if you ever, feel, the need to, ask, additional questions about what the people are asking, to certainly feel free to direct those questions, to them as we're going along this process. And that has been, working, and as we have been going through so far. And, the insurance companies are there to, to be asking these kind of questions, but they're also there to be helping in the process as well. So I feel like in a lot of respects, this is something that, a lot of people feel that, this is something that is going to continue to evolve.
As it relates to, I think, communicating with the insurers too, I've seen, I'm sure as you all have too, on cyber policies, the requirement for a lot of pre-approvals or tasks or analyses to be performed before certain events can take place or be approved in the process of responding to an incident. For example, on a lot of cyber policies, you need approval from the insurer if you're going to pay a ransom demand. At the same time, insurers are now requesting evidence or conversation or representation that the appropriate OFAC analysis has been done to confirm that the threat actor organization making the ransom demand and who the payment might possibly go back to isn't on an OFAC list, right? They aren't a prohibited terrorist organization. They're also, in some instances, looking for new valuations to be performed, right? Is the value of paying the ransom going to be less than the total perceived loss of business interruption or revenue, such that making the ransom payment at the dollar value, makes sense under the policy? So how are you, and this is a question again, for Carolyn or Scott or Sean, how are you managing that, approval process, getting those approvals swiftly or ticking the boxes for the prerequisites that are necessary for coverage in an incident that is moving at breakneck speed, and when you're on calls all night long and the facts are evolving? How do you manage that process?
Sure, I'll take a shot at that, Karen, if it works for you.
Sure, go ahead, John.
So as part of the project management role that we play in helping manage and coordinate the response to a data security incident, one of the roles we play, and we try to educate the client or the insured at the outset, is that we will run interference for them with regard to the prior approvals. And it's going to be critical that every penny we know is going to be spent receive the prior approval of the carrier before that occurs. And so as that initial crisis call, if you will, to assess what's taking place, when you explain what your role is, and that's going to be one of the critical roles you're going to play, then when you bring that first resource in, maybe a forensics firm, you explain that they're going to come in not just to assess what, gather the facts so they can ultimately investigate what happened, how it happened, when it happened, and make sure we remediate properly to shore up those vulnerabilities. But also they're going to produce what we call a statement of work. And then we're going to take that statement of work, it's going to be our responsibility then to present that to the claims counsel immediately after we receive it, so they can review it, hopefully approve it, and then we can execute it. But we don't want anything done before that contract is actually approved and then executed. And then again, every penny that's spent that otherwise doesn't come from retention is going to be covered by the policy. So it's just a protocol that should be followed every single time. When you think about a penny spent, is that going to be covered, part of the claim? Make sure that you've got something in writing that is otherwise approved. But also in terms of the information that flows, one of the things that, to Carolyn's point earlier, we want to make sure that as part of this process, historically, clients were oftentimes aligned with carriers, and we decided to say that they might fall within the common interest exception to the attorney-client privilege. So we encourage the client to share more in order to make sure the claims process goes rather seamlessly. And what we find is there's inevitably there have to be a sharing of information, and the policies typically have a duty to cooperate. And oftentimes insurers don't realize that even if they're defensive, they're worried about liability, at some point they're going to have to, based on the contract they have, actually cooperate and share what the carrier needs in any event. And so as part of the process of getting the approval for the statement of work, we're likely going to share information about what's taking place with the carrier so they see that it's reasonable and necessary expense to get from one side of the incident to the other.
Kari, you might imagine my view about coming in after the fact where carriers say, well, you breached the duty to cooperate because you wouldn't give me every single thing and tell me about every single detail of your day, or you didn't seek permission in advance, is something that I can't agree with what the carriers are doing. Certainly, if you're able to get approval in advance and the carrier is being cooperative and not fighting you on coverage, then it makes for a circumstance in which you'll take the sand out of the gears. But carriers love to both throw sand in the gears and then blame you for not doing every single thing that they want. So taking a position that coverage is limited, or there's some other way they can deny, or investigating as to rescission and then demanding everything under the sun and saying it's all your fault for not giving them everything that would just allow them to deny coverage. I mean, of course, I agree with what Sean is saying, is that there is a duty to cooperate and there is language in there. And if the policyholder has a carrier that's doing the right thing, providing the information, presuming that the carrier is taking a good coverage position, not super aggressive, then providing the information, giving them what they want is appropriate. But there's also case law saying that a carrier can't have it both ways. The carrier can't say that there's no coverage or question whether there's coverage or give the right to independent counsel and yet still try to control everything. But that's never stopped a carrier from asserting that they can do whatever they want, in my experience.
It sounds like from the pre-approval process too, from Sean and Carolyn and even Scott, having, much like the application process and questions about coverage and risk, having conversations with the underwriters, with your broker in advance to get some of those pre-approvals, right? To Sean's point, if you want to use company X to do your forensic work, even if they are or aren't on the panel, talk to the underwriter, talk to the insurer, talk to your broker and say, hey, what can we do to get this pre-approved? Also, what can we do to get the paper pre-approved, right? So the moment that we need to engage them, we already know what the document's going to look like. We already know what the tri-party arrangement is going to look like, and do all of that in advance. It sounds like a lot of risk mitigation in the insurance space is preparedness, if folks would agree with that. I know we just have a few more minutes left. I did have one question on the board amongst the many that I thought was really interesting. And I know it's sort of off script from what we were going to talk about today, but it goes back to preparedness, which is, when you have a parent company, right? A lot of companies are parents or subs, and it's possible that the subsidiaries are covered under the parent policy. When you're thinking about answering questions about cyber framework, cyber infrastructure, how can you maintain accuracy but still answer as to the parent and answer as to the sub? And maybe, Scott, this is a question for you or for Carolyn. Is it, again, adding addendums, adding, additional text box?
Yeah, if you think about, well, could the carrier take this position or raise this question? The answer is yes. Does that mean it's correct? No, but if there's a differential between the parent and the sub in terms of procedures, process, et cetera, then ideally an addendum explaining, we answered this way for the parent company, subsidiary, or the newly acquired company, whatever it is, may be different. Whatever you can do to disclose any differentials would be the perfect world of trying to, again, keep sand from being thrown into the gears.
And I think, Bruce, do we have any time for any more questions, or have we run out of our time now? I see you have
run
just
out of our
joined.
time.
Okay. But
I was going.
sorry,
Sorry.
go ahead. I was going to say, well, thank you to the panelists, to Scott G, Sean, Scott L, and Carolyn. This was a lively discussion. We had a slew of questions. We'll see if we can lob those over to our panelists, and to the extent you've provided your name and contact information, we can certainly have them follow up with you about the questions that you may have had. But thank you again for this opportunity. It was a wonderful discussion.
Kari, very well done moderating. Thank you so much. And Scott, Sean, Scott, Lashway, and Carolyn, thank you all for a great session. This was indeed very lively, 1 million questions and 2 million chat entries. So thanks, and we'll see y'all soon.